I'm Matt Ford, and I am a staff writer at the New Republic, where I cover law, democracy, and the courts. Those three issues are looming pretty large this year, especially after last year's historic term at the Supreme Court. My cover story for our November issue is about Chief Justice John Roberts, the Supreme Court's rightward lurch, how we got here, and what might come next. You can check that out on newsstands and our website. But tonight we'll be discussing the Supreme Court term, which has no shortage of blockbuster cases on the docket this year. We'll also be talking about the changing national perception of the court and what its future might look like, including perhaps even the possibility of reform. And I'm honored tonight to be joined by three of our nation's best legal experts and analysts to help us better understand these issues. Sherrilyn Ifill is a civil rights lawyer and scholar. She most recently stepped down after 10 years of leadership as the president and director-counsel of the NAACP's Legal Defense and Education Fund. It's the nation's premier civil rights law organization fighting for racial justice and equality. She currently serves as a senior fellow at the Ford Foundation. Leah Litman is a professor of law at the University of Michigan, where she teaches constitutional law and federal courts. She's also co-host and co-creator of Crooked Media's Strict Scrutiny podcast. It's a podcast about the Supreme Court and the legal culture that surrounds it. Professor Litman has worked on multiple cases that have reached the Supreme Court, including Whole Woman's Health v. Hellerstedt, which was the successful 2016 challenge to several Texas abortion restrictions. And we're also joined by Wendy Weiser. She directs the democracy program at the Brennan Center for Justice at the New York University School of Law. It's a nonpartisan think tank and public interest law center that works to revitalize, reform, and defend systems of democracy and justice. Her program focuses on voting rights and elections, money in politics and ethics, redistricting and representation, government dysfunction, rule of law, and fair courts. And I'll start by asking a question for each of our panelists, starting with Lee. What should Americans expect from the Supreme Court in the next 5 years?
I think in general, they should expect the worst. And I say that as someone who is in Michigan, because Michigan anticipated what this court would do in the future, specifically after Justice Kennedy retired and was replaced by Justice Kavanaugh, and also seeing the appointments that President Trump was making to the Supreme Court. People in Michigan organized a ballot initiative to get an initiative on the ballot to protect reproductive freedom. And they started that well before the Supreme Court took Dobbs versus Jackson Women's Health Organization, the case it would ultimately use to overrule Roe versus Wade. And I think anticipating things that will change in the future and doing things to safeguard those rights, safeguard those communities in advance of the Supreme Court taking them away and making our country less democratic. That's what people need to be thinking about now, doing those protections, doing that kind of work before it becomes even more difficult to do so.
Wendy?
So one of the principal projects of this Roberts course has been to attack democracy and voting rights and racial equality across the board. And we have seen them systematically dismantle key protections of voting rights, systematically dismantle the guardrails campaign finance regulations across the country, systematically dismantle the protections against extreme gerrymandering and discrimination in the redistricting system. And we are seeing now 2 cases on the docket that could make it get worse. So one of the things that we are bracing for is the Supreme Court continuing to be a regressive force in the ongoing struggle for democracy and equal rights in America. As Professor Litman said, we should be looking elsewhere to bolster our systems of democracy and justice, in addition to the courts. I mean, the courts are necessary, but we need to be looking to the states. We need to be looking to the political process. We need other sources of protections because the court has been regressive and looks like it's going to continue to be so.
Sherrilyn?
So I'm tempted to say something wonderfully optimistic, but I just can't think of anything. I agree with Leah and Wendy without a doubt that trying to get out ahead is very important. one of the things that's most disturbing about this moment is that the current court seems prepared to realize some long-standing wishes of individual justices. We see this with the Voting Rights Act, which has been in the crosshairs for Chief Justice Roberts and Justice Alito and others for some time. We obviously see it with Dobbs. And so I think we have to be, and I think we may see it with the ICWA case. I think that, the court feels at this point, having this 6-3 majority, that almost it would be a betrayal for them not to kind of run the tables on the projects that they have been thinking about for some time, that have been part of kind of the conservative agenda for some time. So I think we should expect to see them fulfilling that. I do want to say one thing about the prescription that Leah and Wendy offer. It is a prescription that is only available in certain states. And so there isn't going to be a statewide referendum protecting abortion rights in Alabama. There isn't going to be one in Mississippi. There isn't going to be one in Florida. And if there were one in Florida, then Governor DeSantis and the legislature would figure out how to reverse it, as they did with the voting rights of formerly incarcerated persons. And so I think I say this because we really actually have to talk about the court. We can't delude ourselves into thinking that some other place is going to be able to deliver, because given the recklessness we've seen from this court, it's not entirely clear to me how, if some of these state measures make their way into the Supreme Court, how the court might respond to them. So I think we're in a very serious and troubling place that requires us to think about our entire democratic infrastructure. And I think people spend a lot of time talking about Congress and a lot of time talking about the president, and a lot of time talking about the decisions of the court, but not so much the infrastructure, which has allowed, a kind of rogue element on the court to do what it is currently doing.
And just to continue with that, Michelle, I know you've covered these issues before in terms of the two major blows that the court could deal this term to the second Reconstruction. We're looking at Merrill v. Milligan, which addresses Section 2 of the Voting Rights Act. We're looking at the Harvard and UNC cases about affirmative action and race-conscious admissions in higher ed. How did we get to this point where these issues are suddenly before the court and are imperiled, it looks like?
Well, kind of brick by brick. I don't think we're in a weird place in terms of these issues making their way to the court. I think the court is in a weird place in the way it's behaving. Every 10 years, there's redistricting litigation, right? That's going to happen. The question is whether the court is going to, in any way, respect the rules and the processes that have governed how we review racial gerrymanders in the past, and whether the court is going to make up something new. So we see the march, right? We see the court from the Shelby case, which ended essentially Section 5, the preclearance provisions that actually held back a lot of the voter suppression that we're seeing now metastasized around the country. That was in 2013. Then we saw, was it last summer? It's all running together for me. The Brnovich case, in which, the chief hands the pen to Justice Alito, of all people, to basically rewrite the test governing Section 2 cases for vote denial. Makes it up out of whole cloth. What does Justice Kagan describe it as? Either text-free or law-free? I can't remember, in a kind of a law-free zone. And now you're right, we're facing Merrill versus Milligan. So for me, the question is, are they prepared to do what they did in Shelby and Brnovich, which was really run through the fences, which is to say, we're not going to tinker with this and figure out, does this comply with Section 2? I think on the facts of the Merrill versus Milligan case, it's impossible to determine that Section 2 was not violated. And it's actually really, really hard to get past the decision of the 3-judge court finding that Section 2 was violated. So you'd have to do some real violence, right, to the very regime itself in order to get where it appears this court wants to go. And I felt some of that when Justice Alito was asking questions about this, the computer simulation. Somehow that, I started out as a voting rights lawyer in 1988, like I did redistricting in 1990. What the computer simulation is now the comparator. You have to have a race blind comparator. That's new, something the state of Alabama made up, and it should have been dismissed out of hand by the justices. But it was interesting to hear Justice Alito talking about this as the impartial way of redistricting, and a reminder from his confirmation hearings when he was asked about his opposition to Section 2 of the Voting Rights Act, amended Section 2 in 1982. And he said it was because his father had worked in the legislative map drawing section of the New Jersey government. And that all he could remember was that his father now had to work even harder redoing maps because of the new laws governing voting rights. And that his kind of resistance to the Voting Rights Act stemmed from seeing his father, up late having to do this extra work. I'm going to leave that story alone, but that's what I heard when he was asking. I'd forgotten the story, but when he was starting to ask about the computer that could do it so simply, I thought about that. And it's just a reminder again that the justices have long-standing views and sometimes grievances that unfortunately come out in these cases. And so when the courts then, sound shocked and bewildered that confidence in the court is at an all-time low, we should just remember that there's a context in which that happens.
Well, I'm glad you brought up Justice Alito and his unique approach to precedent and the law and writing Supreme Court opinions, because we just came off the heels of an excellent example of that last term when the court struck down Roe v. Wade and Dobbs v. Jackson Women's Health Organization. And Leah, I know you've worked a lot on reproductive rights. There's been a lot of discussion about what the court did in Dobbs. Are there any lessons or signals for us in how the court went about it?
I mean, several that I can think of. One is just how reckless the court is.
Yeah.
It gave a version of history that is, to put it mildly, oversimplified. And that's the most charitable explanation that you can probably offer. Then when the draft opinion leaked in early May, it was actually an opportunity for the court to revise its opinion in light of the serious omissions and kind of mischaracterizations that were made in the opinion. And yet the final opinion looked basically like the initial draft, almost as if the reasoning didn't really matter. And what was important was just the bottom line conclusion, which they were going to reach no matter the path and no matter the process it took to get there. So one is just kind of how reckless the court is in its decision making. Another is how it truly doesn't seem to care about the consequences of its decisions on people's lives or the broader public perception of what the court is doing. The court initially granted this case Dobbs based on Mississippi's representation that they were not asking the courts to overrule Roe versus Wade. That was what Mississippi's original petition for certiorari asked the court to do. And it was only after Justice Ginsburg passed away and was replaced by Justice Barrett that Mississippi changed its tune and all of a sudden asked the court to overrule Roe. Usually when a party changes its position from the petition for certiorari to the merit stage, that's a reason the court will dismiss the case as improvidently granted and not decide it. Instead, this court was in such a rush to overrule Roe versus Wade. They just did it, even though they had granted this case based on the representation that it didn't require them to overrule Roe and that the state wasn't even asking them to overrule Roe. They did it so quickly, despite the fact that there were these trigger laws on the books, and states were immediately rushing to courthouses asking, courts to lift injunctions against a variety of abortion restrictions, ushering in these major sweeping changes that frankly created a lot of chaos and are still creating a lot of chaos as people struggle to figure out what many of these archaic, outdated abortion restrictions enacted in the 1800s do. I mean, here in Michigan, we have a criminal abortion ban that was originally enacted in 1846. Wisconsin has the same. And it's not clear whether some of these restrictions, in addition to restricting abortion, also restrict contraception. And it just doesn't seem like the court thought about this at all, or if it thought about this, it didn't seem to care. And the erasure of women and pregnant people from that opinion is, I think, really startling. The most attention that opinion gives to women and pregnant people is to say they're not without political power, but that's no excuse for taking away people's rights and forcing them, to potentially plead for their lives when they are in need of medical care. So just the heedless, reckless nature of the court's kind of irresponsible, hurried decision-making is, I think, a cluster of lessons that I take from Dobbs and makes me really worried about what the court is going to do in the future, because it's almost like they have created this alternate universe for themselves where when in their circles or in their media, they are being told, oh, you're doing great, you're being brave, you're being fearless and principled, then that's all they care about. And they don't care about, again, the consequences for the broader public, the consequences on the broader public's perception of the court, or the consequences on the broader public's lives, health, and safety.
I'm glad you mentioned the alternate universe thing, because one of the things that I constantly have to deal with is cases where they reach the court and the public, people that I interact with, friends from college, people who don't really tune into this stuff, when they ask me about them, that really clues me in that this is something that's really resonating. One of those this term is Moore v. Harper. That's the independent state legislature theory case. I've gotten more questions from friends and family about this case than any other than Dobbs. In the last few years. People really want to know what this means. And so Wendy, I have to ask, what does this case mean for American democracy? How pivotal could it potentially be? What are the stakes here?
Well, the stakes of this case couldn't be higher. Actually, conservative retired judge Michael Luttig has recently written that this is the most important case affecting our democracy in the last 200 years, and whether it's one of them, it does show the state, the recognition of the great stakes at issue. The case involves the two North Carolina legislatures trying to overturn a state Supreme Court ruling banning or overturning a partisan gerrymander, an extreme partisan gerrymander in the state of North Carolina. And they do so by asking the court to accept a radical new theory called the independent state legislature theory that they say holds that under the Constitution, only state legislatures can impact making of regulations of federal elections. That means that they have virtually unchecked authority. All of the usual checks and balances, gubernatorial vetoes, constitutions, state courts don't apply. They won't allow decisions, ordinary day-to-day decisions, to be delegated to election officials. So this is a dramatic expansion of the power of state legislatures with to mess with federal elections at a time when we are seeing a lot of abuses in state legislatures, a dramatic spike in vote suppression laws, a new rise of election subversion legislation that enables partisans to meddle in elections. So the consequences could be really, really dramatic depending on how the court rules. There's a lot of different ways in which the court could slice it, but in any way, it would dramatically cut back key checks on the abuse of power by state legislatures in the federal election process at a time when we're seeing a huge number of abuses and a rise of a very dangerous anti-democratic movement that is actually seeking to sabotage elections or suppress votes.
And this is pretty, and just to follow up on this is pretty unusual in the grand scheme of American constitutional law, right? The idea that there's this whole separate body of laws that state legislatures can pass that are completely insulated from, governor's pens, state courts review, anything like that. It really is sort of an unusual theory in the grand scheme of history. Is that correct?
It is completely ahistorical. No state has ever made election law that way. This is completely the opposite of what the founders of the Constitution meant. They actually were wary of state legislatures and the abuses they might have in the legislative process. They were trying to add additional checks. The whole purpose of this clause was to empower Congress to override anything that state legislatures do, because they were so worried that they might abuse their powers and do things like vote suppression and gerrymandering, like they had their early versions of that. So it is completely upside down. And if I can just follow up on what Leah was talking about on the abuses that the court itself has engaged in, this is in many ways a problem of the Supreme Court's own making. This case, what has come up on multiple occasions on the court's shadow docket. Through the last couple of years, the court has used this emergency orders where they don't have briefing, where they don't have arguments before them, to issue a lot of rulings that affect elections. According to Professor Rick Hasson, there were 16 in the 2020 term alone. And those have actually dramatically changed election law and how courts respond to voting rights, so much so that actually we're seeing a complete halting of voting rights rulings in this year in the lead up to the 2022 election. Several justices in the last term have expressed an interest in this radical theory and essentially invited this theory to be brought before the court. So this is something that has always been discredited and hasn't been how our Constitution worked, but is now before the court and could actually upend our entire electoral system at the invitation of justices in this shadow docket.
And this also isn't operating from the background, on a neutral playing field. There's a history to this and sort of a prior record of reasons to be worried about, malfeasance, disruptions in the election system. Sherrilyn, I remember after the 2020 election, the immediate aftermath, not January 6th, but the day after election day, there was sort of a sigh of relief among election experts and some people that things didn't completely collapse on election day. And you pointed out that in a piece for Slate that the 2020 election did not go smoothly, or at least not as smoothly as people thought. There were instances of voters waiting in long lines to vote that were unfairly denied the opportunity to do so. How much has changed in the last 2 years? What's the outlook for this next week?
Well, that question could take answering that question could take the entire hour. And by the way, I do want to get back to affirmative action, which I didn't end up talking about earlier, which is really important. Mm-hmm. It's a really interesting question, Matt. So first of all, there is this dance, this habit in which there are all these fears about what's going to happen in an election. The election comes, turnout is high, and people go back to whatever they were doing and they say, see, our elections are fantastic. And essentially what that means is that the Herculean efforts that voters have gone to in order to vote, and the Herculean efforts that advocates and civil rights organizations and lawyers have gone to protect the vote, to make sure that polling places stay open later because the power cords weren't there in the morning, to make sure that there's appropriate signage, to make them correct information about who files a provisional ballot and who doesn't, to make sure that people have the right information about where to vote and how to vote, to make sure people know that if they stay in the line, they can still vote at 8 o'clock, to get people the proper information. In 2020, when I was still leading LDF, we learned a few days before, the week before the election, that 20 counties in Mississippi had changed polling places. We ended up having to text at considerable cost every voter we could find to tell them where their actual polling place was. So the success of those efforts, the extraordinary success of advocates and civil rights organizations, and then the grit of voters who were determined to vote no matter what, is used as a kind of a whitewash, for lack of a better word, to suggest that there are no problems with the election. In 2020, we saw levels of voter intimidation that were unbelievable, that I hadn't seen in my 30 years of voting rights litigation in jurisdictions all over the country, but especially throughout the South. And then we cannot discount what we saw right after the election, right? When we saw mobs surrounding the counting place in Detroit, when the license plate of ballot counters in Atlanta were posted on Facebook. Oh, I'm sorry, were posted on Twitter. So the election in 2020 was extraordinary in my view, because it was about the grit and determination of voters who, in the midst of a deadly pandemic, were determined to hold on to democracy in this country in both the primary and the general election. And I said in that Slate piece that, you know, I became kind of radicalized more than I am by the primary election, by seeing all those voters in Wisconsin, Black voters in Milwaukee, where the pandemic rates, this was in April, the first week of April 2020. And advocates had gone to court to try to get the ballots for absentee voters, the deadline extended so that those votes could still be counted. The Supreme Court turned that away. And so people understood they had to show up. If they had sent in their absentee vote late, they had to show up. And to see that in a city like Milwaukee, where 85% of those who were either infected or dying of COVID were Black, to see Black voters standing in those long lines determined to vote just infused me with such a sense of encouragement. 9 hours in Fulton County in the primary, Fulton County in Georgia, you know, Black people standing on line. Same in Harris County, Texas. Remember, we saw people at 1 o'clock in the morning still casting their vote. Mm-hmm. So what changed? What changed is in response to that show of tenacity, of determination, of civic pride. We had a new slate of voter suppression laws that were rolled out in the beginning of 2021. And those laws were a response to the grit and determination they saw in 2020. That's why the Georgia voter suppression law says you can't give refreshments to people standing in line, because that's how people were able to stand in line for 9 hours in Fulton County, because people were bringing them refreshments. So they were responses to what we saw in 2020. And this, in some ways, to me, is the most shameful aspect of this, and I think hasn't gotten enough play, that, you know, in the name of ballot security, these voter suppression laws were passed to punish voters. And you hear this frustration in the Black community. Y'all are telling us to come out and vote again. We've got to vote. We did vote. We did vote, and they came back even harder against us. The truth is we have to just keep this fight going. But I do think it's important to note that the voter suppression laws we saw in Texas, in Florida, in Georgia, in early 2021 were a direct response to the levels of turnout and the determination of voters and the extraordinary work of civil rights lawyers and advocates that we saw in 2020.
I want to give you a chance also. You mentioned the affirmative action case, and I should have followed that up. My first question for you. That was sort of an extraordinary oral argument session.
Well, that's a nice way to describe it. Extraordinary indeed. It was extraordinary. I will say just a few things about it, and in terms of what I thought were moments that were particularly important. Mm-hmm. I want to say first and foremost that for those who, there were many people saying, who cares what happens in the argument of this case? We all know how it's going to turn out. And I never believe that. I believe every moment that you have the opportunity to speak truth to power, to speak to the American people, but more importantly, to make it hard for judges to do things that they want to do that are not warranted by the facts, the law, or the record in the case, you have to do it. And it happened in this case. Now, people focused a lot on the judges for sure. And I would say, you know, there were three that stood out for me. One was obviously Ketanji Brown Jackson. Thank goodness that she was not recused from the UNC case, although she was recused from the Harvard case because she'd been on the board. It was important for people who ask, what difference does it make having a Black woman justice on the court? Why does race even matter? I think if you listen to that argument, you will understand, because she could make the argument in very particular and important ways. That hypothetical about the, you know, the student, the applicant, you know, who's descended from 5 generations of UNC alumna versus the applicant who is also a North Carolina resident, you know, descended from five generations. who were unable to go to UNC, and who could talk about that experience and that legacy, right? Because I think the words legacy, like heritage, have been taken over to mean a certain kind of thing in terms of white people in the South. But it's also a legacy to have overcome and to be descended from a family that's overcome in the way she was describing in that hypothetical. It changed the entire room. It changed the entire tenor of the argument. It literally shifted the atmosphere. That's how powerful and important it was. That was one. Two was Justice Thomas saying, you know, I don't do all that feel-good jazz, all that, those funny, crazy things the kids do. School is about chemistry and math, and what difference does diversity matter? I've never understood it. So here is a man who was part of a cohort of 10 or 12 Black boys who were picked essentially by a white priest and encouraged and supported to attend Holy Cross High School, which is what he did, along with a number of other extremely talented Black men, including Ted Wells, the Uber lawyer, who's a partner at Paul Weiss. Here's a man who went to Yale Law School with affirmative action firmly in place. Here's a man who did not have a job when he graduated and was plucked by Senator John Danforth to go and take a job at Monsanto. Here is a man who, despite the fact that he had no civil rights record, was picked by President Reagan to lead the EEOC. Here's a man that President George H.W. Bush, when he was nominated, said was the most qualified lawyer in the country. Is saying that not only does he not understand affirmative action, but what's the point of diversity? This is a person who's in an interracial marriage. This is a person who has who shows up in all of these environments where he's one of the few Black people, but he's going to pretend and seem incredulous and confused about why it matters. And I thought that kind of performance, I think, is particularly insulting in this moment, because he obviously does know what difference diversity makes. And then I would say third, what I found really fascinating was the ways in which, and this is why this argument was so important. First of all, Elizabeth Prelogar was the standout. She was an absolute superstar. She was amazing. And she, by the way, if you haven't heard the answer, answered Justice Thomas's question about what difference diversity makes quite well. But there were two moments where Justice Alito and Justice Roberts became, I thought, angry and incredibly frustrated and maybe even enraged. And the reason for their rage was that the record simply doesn't support what they want it to support. And Seth Waxman, counsel for Harvard, has mastered that record. And so when Justice Alito wanted to insist that the record shows discrimination against Asian American students, and not only does the record not show it, but the district court found that the record does not show that, and the Court of Appeals upheld that, he became incredibly frustrated and then suddenly said to Seth Waxman, but let's go back to Bakke. Do you think Justice Powell knew that the program at Harvard, for affirmative action actually started with quotas for Jews? Did Harvard pull something over on Justice Powell? I mean, it was extraordinary. And then for Chief Justice Roberts, he became angry as well when the facts didn't work on his behalf, and he put out some long hypothetical, and then he said, "Okay, well, let me try another one." I mean, he was kind of furious that the record wasn't working out for him. So the last thing I'll say is that goes to the point I made at the top, which is if they're going to do this thing, if they're going to decide that they want to end affirmative action, they're going to have to do two things. They're going to have to run through precedent and overturn precedent, which they've shown a clear appetite for doing with Dobbs, because remember, race-conscious admissions were upheld by the Supreme Court in 1979, in 2006, in 2013, in 2016. So if they want to do it, they're going to have to run through all those precedents. Okay. But the other thing they're going to have to run through are kind of what we call the rules of litigation, which is that the factual findings of a district court are not to be overturned unless they are clearly erroneous. And in this case, we have a strong, powerful record, detailed record from the district court, factual findings upheld by the Court of Appeals that this court will have to ignore. Now, they can do it because we've already established that they're the 800-pound gorilla and they can do whatever they want. But putting them to their paces is important. And so I thought the argument was important because we need to see more and more. It needs to be revealed, the liberties, the license, what Leah called the recklessness of this court. in running roughshod in their headlong effort to get to the result they want, running roughshod over even the rules of litigation and litigation practice that we all know and that many of us have taught and that are part of our profession in order to do it. Because that actually further undermines the sense of legitimacy of the court's decisions. Later on, they will be wide-eyed and say, we don't understand why people don't have confidence in us, but that's part of it as well.
Well, and you know, this is an issue where Alito and Thomas seem to agree with each other. But one of the things that really struck a lot of people in the Dobbs decision was that they sort of parted ways on what came next. And Leah, I want to ask you about the concurring opinion that Justice Thomas wrote in that case, where he you know, looks at Alito saying, this case is only about abortion. This is a ticket good only for today. And Thomas says, well, you know, the court should have an opportunity to hear these other cases, these cases involving same-sex marriage, involving contraception. What do you think the future holds? Do you think the court will go further than abortion rights on these issues?
Yes, and if you believe Justice Alito's this is good for, you know, abortion only, I have several bridges to sell you. You know, on the Justice Thomas concurrence in particular, I just note a few things. One is that if you look back 10 years ago or 15 years ago, many people were dismissing some concerns being expressed about the Supreme Court on the ground that, well, that was only Justice Thomas's position. Well, guess where the Supreme Court is now? There were where Justice Thomas was, right? Like 5 years ago, 10 years ago. He is, right, really on the forefront of the direction of this court and where this court is going. I think people need to take seriously that the views he is staking out and has staked out are views shared by a large number of justices who are currently on the Supreme Court, and they will act on those views in the future. On the specific views expressed in the concurrence, I mean, you don't have to look back, but a few years ago, when Justice Alito himself joined a statement with Justice Thomas expressing concern about the court's previous decision in Obergefell versus Hodges, the decision protecting the right to marriage equality. And both of those justices then just a few years ago said, we're kind of interested in limiting or maybe overruling that decision because they didn't think it expressed sufficient respect for their preferred religious views. So even Justice Alito himself has specifically called on the court to revisit some of the rulings that Justice Thomas just echoed that statement, right, reiterated that statement in Dobbs itself. And then third is just the logic of the opinion. I mean, the joint dissent is completely right that either all of the reasoning in the opinion is a lie, or these other rights are at stake, because the reasoning in the opinion is nothing in the text of the Constitution protects the right to an abortion. There aren't state constitutional provisions or judicial decisions in the late or mid 1800s or early 1900s protecting those rights, nor treatises arguing that they were protected, you know, during that time. You can say the same things about the right to contraception, the right to marriage equality, the right to interracial marriage, right? And the list goes on. And so the logic of the opinion is those other rights are in jeopardy. And the only real distinction the court offers in the opinion is abortion, quote, implicates a profound moral question. But these justices in the majority have said the same thing about contraception, marriage equality, and other things too. So you can't take them seriously at that statement either. So all of the signs are indicating these other rights are in real jeopardy, right, at some point in the, you know, near or nearish future. And we should take very seriously Justice Thomas's concurrence, again, in part because, like, he is often, you know, out front of where the court will be in 2 to 5 years.
Yeah, I was surprised to hear from Justice Alito that you know, the Supreme Court doesn't usually deal with constitutional rights that raise profound moral questions. It seems to be that they actually kind of do that a lot. And on, you know, reproductive rights specifically, there was also the concurring opinion by Justice Kavanaugh, where he sort of also tried to, you know, maybe looking with an eye towards the public, say that, you know, the Constitution is neutral on abortion, that you know, he laid out some areas where he didn't think the court should go further. Do you think this is the end of the road for the court on abortion and reproductive rights? Where does this go next?
I mean, we are certainly going to see future abortion cases at the Supreme Court, whether they are cases about the right and ability to travel interstate to obtain abortion, whether they are about the ability of states to prohibit medication abortion when the federal government has approved medication abortion, right, for safe use and by prescription via telehealth. We are going to see cases where states attempt to classify certain forms of contraception as abortifacients and say, well, we can restrict these because we reasonably believe that they function like abortion. So it's not at all the case that overruling Roe, right, gets the court out of the business of abortion. That's a lie. You know, Justice Kavanaugh's statement that the Constitution is neutral and therefore the only way for the court to balance the competing considerations, you know, on both sides of the abortion issue is to overrule Roe is also a lie, right? Planned Parenthood versus Casey specifically struck a balance, the undue burden standard, in order to allow states to protect the interest in potential life and, you know, fetal life and the development of fetal life. So these are just warmed over talking points that don't seriously engage with any of the law, the facts, the state of the world. But again, because they have constructed this alternative universe for themselves, where they are just constantly being told that, yes, you are being neutral. Yes, you are being principled. Yes, you are being brilliant. It's like they've never actually had to defend or test their views in any sort of rigorous way. And they're just uninterested in doing so. But this is not the end of the road on abortion, you know, in this court at all.
And naturally, you know, with cases like this, one after the other, with such major consequences for, you know, Americans' everyday lives, these aren't, you know, just cases that sort of float in the background on arcane principles. These are very real world fundamental issues that are at stake. We have opened now and all along a Q&A section, and people have been sending questions. And Wendy, I'd love to get your thoughts on this one from one of our audience members, Kathleen. She asked, do you think the Supreme Court may lose legitimacy altogether? And how devastating would that be to our constitutional democracy?
Well, I think we're on a very perilous path right now. I mean, the polling public confidence in the court is at an all-time low. And so that is very difficult for the court. That is why we're hearing justices traveling around the country trying to bolster confidence in the court. I don't think speeches are going to be enough to turn the tide. But yes, I do think it's very perilous for our democracy. And I'll sort of start with the point that Sherrilyn made at the outset, that we cannot have a constitutional democracy without a functioning court system and without rights being protected and a reliable rule of law. And so we cannot ignore the court and have a court that is going to be lawless or inconsistent or taking all of these reckless actions. So that is very perilous. We are seeing some support, though, and growing a growing movement to actually think structurally, to think about reforming the court, think about steps that might make it an institution that can regain some sense of legitimacy. Term limits are especially popular. 2/3 of Americans support actually limiting the number of years anybody can any justice can sit on the court. So I think that there are some structural reforms that can be considered. But I do think we need to take seriously this legitimacy crisis that the court is facing.
Let's see. One of the, and just to follow up on that, one of the audience members, Richard, asked if adding 4 justices to the court was even a possibility. Do you feel like, you know, as we move towards the midterm next week, as we look at the possibility that Democrats will sort of lose power to some degree in Congress, do you think the window is closed for court reform, or do you think, to turn a phrase, do you think it's just opening?
I'll start. I think I'd like to hear what the other panelists say about this, but any kind of major institutional reforms or efforts to strengthen democracy don't happen in a short window of time. They take a long and sustained struggle. The fight for voting rights, took many years before the Voting Rights Act materialized and set us on a path towards actually becoming a real multiracial democracy. And now there's a setback in that those same fights are going to have to be waged over a longer period of time. So no, I don't think the immediate future is where I would look to on the viability of these reforms. I do think we need to take seriously the need to strengthen the guardrails of all of our democratic institutions. They are all under serious strain right now.
Mhm.
I think that we need to pass the Freedom to Vote John R. Lewis Voting Rights Act that actually came just 2 votes shy of becoming the law of the land just this past year. That would strengthen, that would eliminate a lot of the problems that we've been facing over the last couple of years, but court reform should also be considered on the agenda.
Mhm. And Sherrilyn, what are your thoughts on where the future will go next in terms of court reform, democracy reform? Do you sense a shift in the national mood, or even just on the left, on these issues that could portend differently in the future?
Yeah, I don't think we have a choice. I think our democracy is in peril, and it's in peril because almost every one of our civic institutions is failing. And our job is to go back and to shore them up, to find out, to identify what the problems are, and to strengthen, each of these institutions. When I left LDF, part of my leaving was wanting to engage this issue. I truly believe we are at the beginning of the need to create a new American democracy, not to strengthen the old one. By that, I don't mean throwing out the baby with the bathwater, but I mean being prepared to think in real and creative ways, accumulating the knowledge that we have, given that we almost went over the cliff on January 6th and we're still at the cliff's edge. So to pretend that we can just kind of do a spackle and paint job is incredibly naive. We need to really dig deep. And as I have said before, the Supreme Court does not sit over our democracy. It sits within it. And if we are examining our complete democratic infrastructure, then that includes the Supreme Court. And I understand that makes people very uncomfortable, makes me uncomfortable too. But I think when you're in a moment of democratic peril, that is the ultimate, civic engagement, the ultimate citizenship is to have the courage to look at the various institutions of your democracy and figure out what needs help. I think we need Senate reform. I've talked about our profession, the legal profession, that has allowed quite a bit of this to happen. I think we need new rules that govern the conduct of the Attorney General after seeing what Bill Barr has done and what others in that office did during the Trump years. I think journalists need to have their own little truth and reconciliation process and figure out how they're going to do the appropriate job that they need to do in a democracy. It's time to examine our faith institutions and what they are doing and how they are undermining democracy and not providing the kind of spiritual succor and nurturing that faith institutions are supposed to. In a democracy, we have to examine our education system. And yes, we have to examine the United States Supreme Court. They don't sit on top of the democracy. The way in which they're structured did not come down on the tablets from Mount Sinai. They were written, some of them were written in the Constitution, not very much, to be perfectly honest. And so Congress still has a lot of power with regard to the Supreme Court. But you know what? The Supreme Court has its own power too. And one of the reasons I joined the President's Supreme Court Commission is really an answer to the first part of your question, Matt, because I do think that change is a process. And I felt that was a first part of the process, that there needed to be a commission of people coming together to look at all of these issues. And one of the things I pushed for on that commission was that we would include a section on the shadow docket and that we would be looking at these other things, not just expansion. It's unfortunate when we hear Chief Justice Roberts say, "We've got this, we don't need you to tell us what to do," because I think there are good suggestions in there about transparency, about disclosures, about recusal practice. and the court, being covered by the same recusal rules as federal judges and having some means of accountability. These are all things the court could do itself. And I think there's a problem when we raise this issue of legitimacy and we see the polls, that what we get back from at least some of the justices is people don't understand. This is outrageous. It crosses a line. It's an attack on the court. People need to be educated about what courts do. Without question, people do need to be educated about what courts do. But the justices on the Supreme Court can't be so above themselves and above us all that they don't think that they are subject to examining their own practices. I mean, I said this about the leak, which, by the way, I'm one of the people who feels that the leak was a terrible thing. A terrible thing in that if I were a judge, I would want to know that my deliberations were private and that would be important for my decision-making and my engagement with my colleagues. So I feel quite sympathetic to how they feel. I also feel quite sympathetic to the idea that, we had a chance to see what was coming, and that was real. But do I want people to leak, drafts of Supreme Court decisions or any court's decisions? No, I actually don't. And I think it's perfectly fine for them to want to get to the bottom of it. But you know what my first thought was? What is it if I were running, the Supreme Court? I've run, offices of over 100 people. And when something happens, the first thing I always thought was, what messages am I potentially sending that caused something that has never happened before in the history of the court? What messages are we perhaps sending by the culture within the court that made someone feel that they were willing to breach something that is so verboten, something that so violates the culture of this institution? I did think it was an opportunity for self-examination, not to suggest that the person who leaked is not accountable for their own actions, but when you are running an organization and one that has that kind of power and that kind of record, self-examination is a good thing. So when Chief Justice Roberts gives his state of the judiciary at the beginning of the year, as he did last year, and says, we got this, please don't tell us what to do, we know what we're doing, that's basically thumbing their nose at what is the low-hanging fruit, which is the court itself examining its own procedures and making changes. The court actually did change some aspects of how it was engaging the shadow docket as a result of the very vigorous debate that was happening in the public and among legal scholars like Leah and others, and also on the Supreme Court Commission. We saw that they began to try to issue decisions, because we all know that written decisions are helpful for people to understand. It's helpful for litigators. It's helpful for parties to understand, what does this mean? And how should we glean this going forward? So the court did start to make changes. So the idea that they're doing everything perfectly and we're just some rubes who don't know what we're talking about is absolutely silly. And the court should welcome the input of people who care about the rule of law, who want to see us have a court that not only is respected, but is entitled to the full respect of the public. And they should be listening to the suggestions that are made and doing some self-examination to figure out what they can do. That it would have to all be imposed from the outside, either from Congress or the president, says something, I think, quite profound and important about this court.
Mm-hmm. I'm going to move to our final question of the evening for each of the panelists. But before I do, I've been asked by them to highlight the Election Protection Hotline. It's staffed by lawyer volunteers around the country with people on the ground in every state. You can call 866-R-VOTE. That's 866-R-VOTE, O-U-R vote. And that will connect you if you run into issues at the polling places and issues with your ballot. That will connect you to people in every state in the union who will be able to help you. And again, that's 866-R-VOTE. Now, one of the challenges for me, and I'm sure the panelists felt this too, is that when you have an hour-long event to discuss the Supreme Court, there is often not enough to talk about, or I'm sorry, the opposite of that, there's often too much to talk about. We could have easily spent another few hours on this. And I would just like really quickly to ask each panelist if there is anything about the court's work that we should know about that hasn't been discussed already tonight. I'd like to start with Leah on that.
I could name some specific additional cases that the court is hearing. They are hearing 303 Creative versus Linus, which could take a huge, bite out of the protections that anti-discrimination law offers. I could say something about the serious, I think, ethical and institutional legitimacy concerns that are being raised by the justices and their spouses' extracurricular activities. The fact that the spouse of a sitting Supreme Court justice was engaged in some of the activities about trying to overturn the results of an invalid election, I think is hugely concerning, a major red sign about a future of a constitutional democracy. The fact that Justice Thomas has continued to participate in cases related to January 6th is just compounding this problem. So I think, part of what I would encourage people to do is try to consume not just stories about what the court is doing on the docket, but also politics stories and political stories about what the justices are doing on the side, like Justice Alito's speech to the Heritage Foundation or Justice Thomas's speech to other organizations. The fact that Justice Thomas is having lunch with Ron DeSantis and his law clerks. It is important to understand the work that the court is doing in the context in which the court is actually doing it.
Wendy?
So another thing that I think would be, we would be well served to pay attention to is and that the court would be well served to pay attention to is the impact that its decisions are having on behavior on the ground. And I don't only mean the impact of the decisions on affected people, like in the Dobbs case, but it actually changes what other actors, what other political actors feel is permissible. It moves the needle, both on people's respect for the rule of law and people's willingness to invalidate other laws or push the envelope further. If we just look at the Moore v. Harper case as one example of that, the fact that the court even considered this has caused a wave of much more aggressive legislation in the states in anticipation of a court perhaps greenlighting that legislation going forward. Every time the court signals that it might be uncomfortable with remedies against race discrimination, you see a big spike in racially discriminatory activity in the area that it's focusing on. It has a real impact on people's behavior. And conversely, the rule of law, under the belief that the courts are going to step in and enforce the basic principles of our democracy and of our Constitution, have a real impact on reining in abuse. We just saw that with a decision stopping voter intimidation in Arizona. That's going to have a real impact on people's behavior across the country. People know now that the courts are there as a backstop, that they're not going to get away with it. The opposite decision would have led to a dramatic increase in those kind of abuses across the country. So the court is an actual active player in laying the groundwork for what abuses people are willing to undertake.
And Sherrilyn, your closing thoughts.
I think that it's really important to note the reckoning with history. That so it's ironic that the court appears to be obsessed with the 17th century and things that are in our tradition, and but reckoning with the history of racism in this country. It doesn't get more stark than talking about Alabama, as in the Merrill versus Milligan case, right? In which, the state is creating districts and making sure that they protect the, I want to make sure I have the right, this, the area of the state where, residents of French, Spanish, colonial heritage, must be protected and maintained within the same congressional district. But Black voters living in the Black Belt and in the city of Montgomery can be cracked and split between a variety of districts. Alabama is ground zero for voting rights in this country. The whole state is kind of a national monument to the struggle of Black people to be first-class citizens in this country. And that's a history that when the court brushes it aside, which, you know, they may be prepared to do, is truly horrifying. They certainly did it in the Shelby County case. It was important that that case was from Alabama, the case in which they removed preclearance. We saw them do it in Dobbs, and we may see them do it in the ICWA case in Brackeen versus Holland, the Indian Child Welfare Act case, that really goes to the heart of tribal sovereignty. So I think this is very important, particularly at a time when we're seeing this movement against the teaching of this kind of history in school. There is an attack on history, and the Supreme Court may be part of that, in the way that it describes or repackages, particularly our racial history, our gender discrimination history, to mean something that it actually doesn't mean. And we should be very mindful of that. And the second thing, I think, is that I'm obsessed with and trying to write about right now is, it seems like insider baseball to people, but I think it's really important, and it's how the court does what it does. It's one thing for the court to issue decisions that maybe you or I don't agree with. It's a whole nother thing for the court to change the question presented to more directly attack a precedent that they would like to overturn, or to do what they did. As awful as Dobbs was, I still believe that what they did with Texas SB 8 was worse, because Roe versus Wade was still the law of the land, and they allowed the most populous state in the country to essentially put a bounty on the exercise of a right that remained constitutional for months until they decided Dobbs. That shook me to my core. You know, I think the shadow docket is yet another area where, when the court engages in, you know, deciding cases that affect the lives of millions of people in a way that is completely opaque, and really can't be understood, when the court has different standing rules, you know, for people who are pursuing religious liberty claims as opposed to those who are pursuing civil rights claims. These things may seem like insider lawyer baseball, but the rules are supposed to be what makes it fair. You know, the outcomes will feel not fair to one side or another, but there is supposed to be the sense that you're playing by the same rules. And increasingly what we're seeing in the recklessness, you know, that Leah talked about, in the headlong dash towards the result, is the Supreme Court deciding that they can jettison the rules that govern how they are supposed to issue decisions and how they are supposed to move through the process. And that seems particularly alarming to me, and is something I don't hear enough about.
All right. Well, thank you so much. And thank you to all three of our panelists, Sherrilyn Ifill, Leah Litman, Wendy Weiser, for joining us tonight, for sharing both their time and their insights with us. If you're looking for the next TNR event, that'll be on November 14th. It's the Run Up Live. My colleagues Grace Seegers and Daniel Strauss will be talking to Representative Jake Auchinclose about the midterm elections, the lessons learned from them, and where the Democratic Party goes next. So please sure to sign up for and tune into that. Thank you all for joining us tonight, and I look forward to seeing you again next time.